Thank you everybody for coming along. It's our 5th contentious clinic from IDR Law. I'm Lindsay, I'm the Head of Business Development and Marketing at IDR Law, and run our contentious clinics each month. They've been a real hit. We've had loads of you coming along each month, so thank you for continuing to join us each month. So the contentious clinics, as you're probably aware, and many of you have subscribed to it, were born out of the IDR network. The IDR network is our online referral and support network, and it includes lots of resources, guides, CPD, training webinars, and basically it's there for either if a contentious case lands on your desk or just for a bit of non-contentious browsing. So today we have Eleanor Stenson, our partner, joining us to run our session today, and we are doing it on the Inheritance Act 1975. Now, the reason for us doing this today is we actually put out a survey to our IDRN members and asked you, what would you like to see us doing some training on? And actually, the 1975 Act, over half of you wanted this training. So we were really pleased to do this today. Eleanor's going to cover off the individual claims under the 1975 Act. She's also going to talk about the pitfalls and benefits of making each claim under the Act. And then we're also going to run through a bit of legal tech with you and how you can harness legal tech when it comes to making a claim under the Act. So what I'll do now is I will pass over to Eleanor and she can kick off with the main section.
Thanks so much, Lindsay, and thanks everybody for coming along. It's always really useful for us to get the feedback that you're giving to us in terms of what you want to see, and it helps us to make sure that's completely bespoke to IDRN members, but also making sure that we're hitting the ground running for you in terms of real life, real time issues. So if anything crops up in your day-to-day which you would like some training on or some guidance, whether that's a formal webinar like this or you want to see it on the IDRN, we're always happy to listen. So thanks again. So today is an overview of the Inheritance Act. This is a really, I was going to call it a whistle-stop tour. It always has to be with this act because it is quite comprehensive. The act itself is, even the title is wordy, and anybody sort of stepping into the legislation website looking for the exact wording of the act will see that it may as well otherwise be known as the land of the subsection and the brackets, because it is so complicated in the way that it's set out, and it can be completely off-putting to you when you want to just go for an easy answer. So my approach today is to take a step back from those subsections. It's to take a step back from those brackets and to look at it as a real sort of high-level overview of basically the reason for it, why it's here, how it's intended to work, who can claim and what their claims might look like sort of in contrast to each other. What happens in that first discussion with a contentious lawyer assessing a claim, and this is where we start to look at the way that legal tech might assist. And also I'm going to talk briefly about the benefits and pitfalls of claims under the 1975 Act. Because each case is so fact specific, it often means that claimants are almost in the dark as to the potential success. And it's the sort of thing that requires the court's input to let them know whether or not they do have a valid claim. So it can be a really scary prospect. And as litigators, we know that it's a risky strategy starting a court claim when you don't necessarily know what the outcome is. But as I say, because they're so fact specific, you might find a case that meets 3 out of 5 of the issues on a new case, but it doesn't quite cover some aspects. And so anybody sort of embarking on a claim under the Act will find themselves wanting to push for an early settlement of their claims, to really look to engage confidently with the estate and the other beneficiaries to the estate, so that they don't have to take that very risky, very stressful, very costly path down through litigation and to a contested trial. So as I say, the aim of today's presentation is to take a step back from the subsections and to some extent the uncertainty of each individual case, and provide this overview of it, and really sort of delve a bit deeper into the eligible claimants and their claims. So looking at the background to the Act, it came about in 1975. There is without it a very binary approach to the law around inheritance. We have estates that have a will, or estates that are governed by the rules of intestacy, and the law here is very clear that people should and can have complete testamentary freedom about how they leave their estate. The issue comes where somebody is not provided for. Somebody who is dependent on the deceased or the testator is not provided for by either a will or the rules of intestacy. So you think, well, if everybody has testamentary freedom and everybody has the right to leave their estate to whoever they wish, does this sort of go against it? Because there's, if there was some falling out somewhere along the way, shouldn't a person be entitled to leave somebody out of their estate? Well, the answer is yes, of course they can, and they can write their will in the way that they wish to. But the law will step in almost as a moral compass to say, actually, no, it is not right for you to not provide for those who depend on you financially. There is limited entitlement to make a claim. It doesn't apply to anybody. You can't just feel that maybe you've been left out by a friend or an acquaintance somewhere along the line, and make a claim and ask a court to provide for you. It has to be a person who is financially or morally close to the deceased. So that is the deceased spouse, the ex-spouse, or civil partner, their child, a biological child, or somebody who was treated as a child, perhaps a stepchild. Cohabitees. Common law marriage doesn't exist. We know that. We know that if somebody isn't provided for in a will, who cohabited with the estate, that they don't have anything, they don't have anything to rely on under statute to say that they're entitled to things. This allows them to claim. The fact that there is a will doesn't mean that that you can't make a claim under this Act, and it doesn't mean that will can't still stand in terms of distributing the estate in the way that the deceased wanted it to. You don't have to challenge that will to make a claim. The deceased may well have been of sound mind and knew exactly what they were doing, but the law will still step in under this Act to ensure that somebody who might have been left out of the will or should have been provided is able to make a claim for provision. And the court looks at it as a pot, the net estate, and in terms of the way that net estate is distributed, any claimant under the Act, if they're made an award, they take provision from that net estate, and then the remainder is distributed in accordance with the will. And that's something which can be helpful, because it in a way, what you can be doing in those circumstances as a claimant is saying to the family or the people who are provided for in the will, say, look, we're not trying to disrupt anything that you're entitled to here. We're just making sure that it works for everybody. And likewise, because of the very, very strict time limit, which is 6 months from the date of the grant to bring any claims, we're not trying to disrupt the administration. We're not trying to hold things up. We're not trying to be obstructive. So in a way, you know, the fact that there isn't a will challenge, you know, can be helpful. But likewise, there may very well be a very good reason why the will or the last will isn't valid. And sometimes these claims under the Inheritance Act will accompany a challenge to a will. So you can see that in such circumstances as if the will was to be invalid and then the estate reverts to being governed by the rules of intestacy, there still, you know, it is a reason for a potential claimant to claim, because even getting rid of the will doesn't provide for them. So in terms of that time limit, then that 6-month time limit, as I say, it's designed so that the types of claims made do not hold up administration. They've got to be done quickly, and ideally they need to be resolved quickly as well. It is possible, if you are running up against that 6-month time limit, that you can either agree with the other parties to sort of pause that time limit and enter into a contract which effectively makes everything stand still for a period of time, so that parties can investigate, they can get all their evidence collated, and then they can hopefully come to an agreement without the need for court proceedings. So just turning to the eligible claimants, I sort of listed these out already, but I think it's helpful to look at it visually, because really you see the closeness that is needed here in terms of the relationship. There's the claimant, if the claimant is a spouse, and obviously this includes civil partners, then it may very well be that in a case of a will being made, and there being a last will ready there to administer the estate, it might have predated you know, the relationship with the spouse. Perhaps it isn't valid for some reason, or perhaps specifically the deceased has left their spouse out of their estate, and sometimes for good reason, sometimes for not good reason, but irrespective, the court will accept applications under this Act for provision by a spouse. Those of you who are familiar with the rules of intestacy know that a spouse tends to benefit greatly from an intestate estate, but that may not be enough. If the estate is of high value, it may be inappropriate for the spouse to only receive their statutory legacy, and it may be that the spouse has to make a claim to say, actually, this does not provide for me and I need more from the estate than the law currently prescribes. So turning then to ex-spouses and ex-civil partners, well, why should they make a claim? Well, the typical circumstances that surround these types of claims are where there are unresolved financial issues following a divorce, and the court allows the former spouse to make a claim to resolve those issues on the basis that the deceased is no longer around to either agree or submit to a court order by the family courts. Then we have cohabitees. Again, this is a very common type of claim. You know, we see very long-term relationships where either a will wasn't left or it doesn't provide for the cohabitee, but the way that the family had, you know, been run and the way that the couple had treated their finances, it would be inappropriate and wrong for that cohabitee not to be provided for. Same with a child, biological child. For minor children, the process is slightly different, but for adult children, it is still possible to make a claim on a parent's estate. And this is done in exactly the same way as the other types of claims. And you know, you're showing the court that there was a link there because you are, you know, it's a parent and child, but also you will need to sort of justify that there was that financial link as well for adult children. Going a bit further distant, you know, away from the closeness of the relationship, treated as a child. Typically, this is a stepchild or somebody who, you know, has been adopted in inverted commas, not legally adopted by the family. Perhaps there is a sort of a niece or a grandchild who has moved in with the family to be looked after, and that would fall into this category. Someone who was treated as a child. They can be a minor child or an adult child, but those are typically the types of people we see in that category. And then we have a last sort of catch-all category, which is somebody who is maintained. It means financially maintained, and it can be somebody who doesn't have that, it doesn't tick any of the other boxes here, but who did have that financial relationship, and the deceased owed a moral obligation to them. Just turning to the way that the court looks at every type of claim under the Act. The court recognises that there's a limited pot here. There's a limited set of resources and assets which are available to meet claims. This is really important because if there are numerous claims, then it can start to be more difficult to carve out the true value of those claims, because there are so many that need to be provided for. Excuse me. The court also wants to know what obligations and responsibilities the deceased had. This is formal, this is something which needs to be evidenced to the court, and we need to be able to produce either very comprehensive witness evidence which sets out how the relationship worked. So, for example, if it was a stepchild, then the evidence would be looking at the sort of way that the family blended, and then the way in which the deceased maintained financially that child. For example, making sure that their education was paid for in the same way as any biological children in the family, and evidencing, the fact that financial support was made to them during university, for example. So looking at bank statements, looking at check stubs, looking at birthday cards, all this stuff which provides that background narrative to that relationship and evidences it. Again, the size of the estate is important here, and looking at the makeup of the estate. So it's looking at whether there is liquid assets available to meet claims, or whether it's going to require property to be sold. and sort of, as well as that, the court wants to see exactly what the people applying for provision have got themselves. So they won't be, it does sometimes feel a bit intrusive when you are talking to clients about what their current financial position is and what their resources are, but it is important because the court does look at the relative need of each of the competing beneficiaries and applicants. So, if you have, in the example of a stepchild, if you have a stepchild who needed and always, required more financial maintenance because perhaps they didn't move out of the family home, perhaps the other children went to university and they've gone off and, found a profession and bought a house and got married and are sort of relatively comfortable, whereas this applicant isn't, and there is more need there. So the court does objectively look at all of the relevant people and what their need is in relation to each other. It's also concerned with whether there is any additional need, so disabilities. If there are any claimants or beneficiaries with additional needs, then the court needs to be aware of it so that they can account for how those needs will either progress, or what those needs might look like going forward for the life of that beneficiary. The other and often very important point which the court will look at in all cases is the conduct of the parties. That means looking at how a defendant has received a claim, you know, whether they've been open about the estate, whether they've made a lot of financial disclosure, whether they've been really, you know, willing to collaborate with the applicant, or on the other side, whether they've just shut down and didn't deal with them, kept things secret, you know, refused to disclose important information about assets in the hope that they could settle a claim at a lower value. It's something that the court takes very seriously, because the emphasis here behind the Act is to bring your claim quickly and to resolve your claim quickly so that the estate can be administered. And anything that prevents that, anything that holds things up and people's conduct that causes obstruction, is something the court needs to know about, because it does have discretion in making any awards, but it also has discretion in awarding costs as well. So if conduct justifies it, then somebody may be penalised in costs for the way that they've acted. Looking more closely at the spousal claims, the starting point here is that the claimant must have been legally married or in a civil partnership at the date of death. The court treats spousal claims slightly differently. There is a specific definition of reasonableness, which is related to what a spouse ought to receive from their spouse on death. This is different in the way that the courts look at, for example, claims by children, because it's expected that children grow up and move away from home and build a life for themselves, whereas a spouse is deemed to be provided for in the context of the home and family life, and financial support for life. There can be sort of different types of marriages. You know, there are plenty of cases which look at completely separate lives between spouses, you know, separate homes, no shared assets, no shared bank accounts. But ultimately the court has to look at this with the benefit of the sort of family court's approach to divorces. So looking at what is fair, what is right, and what is reasonable for a spouse to receive in all the circumstances. The court will look at additional factors, and I'll sort of come on to them in a bit more detail, but the duration of the marriage is clearly important, and their contribution. And the court will effectively conduct a hypothetical divorce when they are assessing claims by a spouse. The age of the applicant and duration of marriage is important, because obviously if they are young and you know, require maintenance for a longer period till they're either to the end of their life expectancy, then their award ought to be greater. Short marriages tend to be treated slightly differently than longer marriages, but ultimately the court is looking at the contribution to the family, the home, the children, the domestic life, as well as any financial contributions that the applicant's made. And then it conducts this hypothetical divorce by looking at the matrimonial assets. Sometimes, even if these aren't held jointly in terms of legal ownership, the court still brings those into the pot of joint assets, and looks to separate them in a way that a family court would do, which then provides for a share to fall into the deceased estate, and then a share to be awarded to the spouse for their maintenance for the rest of their life. In terms of ex-spouses, ex-civil partners, as I mentioned earlier, this tends to be related to unfinished divorce proceedings. If you've only got to a decree nisi and not a decree absolute, then the marriage isn't dissolved. So they're still a spouse. So then you fall into the spousal category if you're making a claim. If you'd reached the decree absolute, but there were financial issues which still needed to be resolved, at that point, you can be making a claim to the court to say these issues were unresolved and we need an order. Ultimately, in these types of cases, you tend to know what the outcome ought to be because discussions had either already taken place, perhaps even papers had been submitted to court to set out what was agreed, and it's more of a rubber stamping exercise. So these types of cases are more easy to settle because they do offer a bit more clarity on the assumption that the parties had already been through a certain degree of the process. However, irrespective, the court does have to look at the age of the applicant, the duration of the marriage, and the contribution to the family, because it is still undertaking that exercise that the family courts undertake to try to ascertain the appropriate award here. Looking at cohabitee claims, they can be particularly difficult where you might have a biological family members who stand to inherit, and they might look to be trying to sell the property and sort of evict the claimant if the cohabitee doesn't have any legal interest in the property. They might be shutting them out of finances, preventing them from accessing possessions, etc. They're often highly emotive claims, and cohabitees have to go a long way to proving and justifying their claim to the extent of financial maintenance. There's a lot of factual elements which are often disputed, such as the length of the relationship and the way in which they live together. The Act says that they must be living as man and wife or as civil partners, and but invariably family members, if they didn't get on with the cohabitee, might say, well, they didn't. The girlfriend or the boyfriend always had their own property, and actually they only stayed over every couple of weeks or something. And those factual disputes can be really upsetting and can be really difficult to advance, because it's very much he said, she said, and the person who is able to clarify the position is gone. We also see cohabitees who were totally reliant on the deceased financially, and actually them passing away is devastating, not only emotionally but also financially. Their access to funds or money for shopping, it just goes, and particularly if you find that sort of biological family steps in and cuts them out. You will often see that these types of claims come with legal funding arrangements where solicitors are offering conditional fee agreements, either with an uplift or a success fee, which can mean that, particularly if you are responding to a claim, or if you are a charity in receipt of a legacy under a will and a claim has been received, then you might find that there is a significant risk of allowing this claim to proceed, because not only does the award have to come out of the estate, but if there is an additional uplift on costs, it can eat into the residue. So it's an important factor to be aware of. How is the claimant funding this? Is this going to impact the outcome, and ought we to be getting this settled at an early stage? There is also provision in the Act for claimants to request an advance on any award from the estate to fund their legal fees. This is something which it can be problematic because there's no requirement to pay that back if the claim is unsuccessful. So you find that if applications like that are received, then irrespective of really what position you are with the exchange of evidence, it really is a a sort of clarion call to say, get this sorted between you, because the more costs that are being taken from the estate, which may not be repayable, you will always end up in a sort of net loss position. So the watchword is early discussion, early exchange of information, and hopefully early settlement. Looking at what the court wants to see, again, they want to see the length of the relationship. They want to see how permanent this was. There is a requirement for a cohabitee to have been living with the deceased for 2 years prior to death. It should be continuous, but there are cases which say that, you know, actually it can be broken up by hospital stays and things like that. And there is, you know, some case law to support if there was an argument, or, you know, something which meant that somebody went and stayed somewhere else for a weekend or whatever. But ultimately, it should be effectively a settled and permanent relationship. And they will also look and want to see evidence of the contribution by the cohabitee to the family, to the relationship, to any children, to the household. So there's a lot of evidence here that needs to be pulled together for cohabitees, and particularly given the 6-month time limit, can be really difficult to get that together whilst you're in the process of grieving as well. Looking at biological children, if it's a minor child, obviously the need is easier to demonstrate, but they do need separate representation, and they need a litigation friend to advance a claim for them. This can eat into costs, and it can overly complicate discussions, but it is a requirement so that child's interests are protected. Just because an adult child has moved out, and just because they may have a job or, you know, may not have a job, it doesn't mean it's impossible for them to bring a claim. We have seen a few successful claims following Eilert and Mitson, but you tend to find that where adult children who are financially settled, financially comfortable, are making claims, at most those are likely to be treated as something of a nuisance claim, or, you know, a claim to sort of be paid out, you know, just almost a notional sum, rather than something which needs to be valued and you know, the merits of it assessed. It's something which can disrupt the administration of the estate, and many executors, personal representatives, will look at this as a commercially effective way of removing the chance of ongoing litigation, rather than the claim itself being particularly meritorious. Sometimes you need a DNA test. If the child, if it isn't obvious, if the child was not, if the deceased was not named on the birth certificate, for example, or if the child never lived with the deceased, and sort of has come out of the woodwork as a, you know, part of a second family, or perhaps a child that the deceased you know, fathered or whatever, you know, many years ago, you may need to just double check that this person does have a valid claim under this section of the Act, because of course if that relationship was not there, and they were a biological child, the court can deal with the claim under this section. But if they weren't a biological child, then they don't fall under any other section. So it's a very important distinction to make. You know, they wouldn't fall under being treated as a child because they were entirely separate from the deceased, and likewise they weren't being financially maintained. So it's an important distinction. And further, we need to look at evidence of their maintenance. Easier with a minor child, naturally, much harder with an adult child. And you know, looking at actually what they need, or what the deceased was providing during their lifetime, can be difficult to evidence as an adult child. The court considers claims by children in the same way as other claims, but particularly for children, both minor children and sort of slightly older, education is something that the court will look at. So whether there is an expectation on funding of education, doesn't need to be private schooling, but it can be go towards university and things, so that the court will want to make sure that it knows what was expected for the child, what obligation the deceased might have had there. Looking at this section, treated as a child, I've sort of suggested here that this is really somebody who lives in the same household, but it isn't biologically related. So we're looking at stepchildren, perhaps even long-term foster care, or other type of sort of informal relationship. That there are many reasons why a family might take a child in at some point in their lives, or even have always lived there but just don't have that biological relationship, and they were never legally adopted. The evidence of the relationship is really crucial here, because without that biological link, you need to be able to evidence really why this person was treated as a child of the family, and not just a friend or a friend of their own children, or something more informal, more infrequent. Then further, you have to go beyond the fact of evidencing the relationship, but also evidencing the financial maintenance and what their need is. When we're looking at this, the court is quite specific, and it looks at obviously whether the applicant was being maintained, the length of time that took place for, and how much really. Was this £10 in a birthday card every Christmas, or was this monthly payments towards university fees? Was it monthly payments towards living expenses, or things like that? But really the crux of it is whether or not the deceased assumed responsibility for that maintenance, and whether or not they knew in doing so that the applicant wasn't their own child. That it will be clear to everybody here that there may be circumstances where a child is brought up as part of a family who isn't biologically related, but there is not that awareness there. So that is an important factor. If the deceased had known that this was not their child, would they have still performed this sort of maintenance and financial support role? And then likewise, was there anyone else who assumed liability for this maintenance? Because if a child is taken into a family to be looked after and treated as a child of the family, but yet they are being financially maintained by their biological parents, and the deceased didn't ever have to pay for anything, that does change things. That financial maintenance link isn't there. Finally, the catch-all is someone who was being maintained and someone who doesn't fall into any of the other categories. This can be really difficult to sort of identify the type of claimant you might have. The way that I see it is, if you have a family where the parents aren't around and an older sibling has taken the responsibility for younger siblings, and has financially maintained them and looked after them and owes that responsibility to them. If that older sibling died, those younger siblings would need to be provided for from that person's estate. So it's somebody who doesn't fall into the other categories, but it is somebody who is looked after and financially maintained by the deceased. Again, huge amounts of evidence required to support the relationship and to support any financial maintenance, bank statements, payments. What did that look like in real life? And the court will want to see how long this was going on for, to what extent financially was the claimant being maintained, and did the deceased assume that responsibility, or was it shared with others? So just coming on to how we might assess these claims, something that occurred to us when we were preparing for this talk was how difficult it can be for clients to take the step to sort of ring up a solicitor and say, I think I might have a claim, I'm not sure, you know, what do we need to do? And those solicitors saying, right, we'll come into the office, we'll go through everything, you know, bring your bank statements, bring a will, bring everything in. And, you know, that meeting can be quite lengthy, it can be quite stressful, quite emotional. And you may find that the solicitor still has to go away and say, oh, well, actually, we're not quite sure, we need to think about it, or pay us, you know, £1,000 on account and we'll provide you with some guidance on whether or not you do have a claim or whether you may have a claim. And what we've developed, and I'll sort of, whilst I'm getting it set up to show you all how it works, I'll hand over to Lindsay in a sec, but what we've set up is a claim checker specifically for 1975 Act claims, which allows potential claimants, or even, you know, if you are a practitioner supporting somebody who's contacted you to say, look, I need a solicitor and this isn't your specialism, then it allows you to sort of sit with them or even have them on the phone to go through details, to get at least a signpost that says, yes, you may have a claim, or no, you don't have a claim here, you don't fall into the categories. And it can just ease that stress of having to come into a solicitor's office and either having to pay for it, or to sort of come away disappointed, feeling like there was some false hope there. So whilst I just switch over, Lindsay, I don't know if you just want to give a little bit.
I thought I'd jump in there. So basically it's just highlighting what Alan has said, really, and the fact that the claim checker's there, it's really accessible, and it's one of those tools that you can use, and basically stops that barrier of the client having to use the lawyer in the first instance. I think it's probably important to note here as well that, you know, it's been widely reported in the news and in the press that 1 in 3 are actually relying on an inheritance, either to fund their retirement, move home, or discharge debt, which is, you know, is becoming more and more evident, especially in this cost of living crisis. So it's kind of the idea behind the claim checker. We wanted to harness legal tech to reach more families and to help more families, removing that barrier, as Alan has said. So it's easy for them to then pop in their information at home or even with their solicitor, and you can go through the flow of the form, easy steps to the form.
And I just check, you can see the claim checker here on screen. So it's within the IDRN, you know, and it's also on our website as well. But if you, I'm sorry. No, it's all right. Go on. You say.
Yeah. So as Alan mentioned, it's within the IDRN. So the link is in the chat. So if anybody wants to have a play with it, they can do. We've also created a widget of the claim checker, so we can actually drop it onto referrer sites as well. So when you are sitting with that client, and if you want to go through the form, it's easier because you can just tap into your own website.
Yeah.
So I think we're just going to give a little bit of
I just thought I'd fill it out if that's okay, and then we can just take it through each page. But I mean, first of all, I suppose, obviously, really, a lot of this will be information capturing for us, because what we don't want to do is sort of either act in a position of conflict or anything, but also what we don't want to do is be really insensitive when we're, you know, contacting your client or your contact and not have the key information there. So we just ask for the name of the deceased, and then we look at the date of death as well, because you know, this can be an important date where, you know, somebody has died long ago. If the estate has already been administered, you know, that there may be a very low chance of actually succeeding in getting a claim off the ground in those circumstances. So we just ask for the date of death, Were they born in England and Wales? That's because of the jurisdiction that we practice in, and we just want to make sure before we even start kind of wasting people's time, if it didn't, if they were if they lived abroad, we can't help them, and we don't want people to have that false hope. We want to point them in the direction of somebody who can. So we'll say here that that Jane didn't leave a will, and we'll say that the grant of letters of administration has been issued, and we will say that it was issued on the 1st of this month. That helps me and anybody else picking this up, because we know that clock is ticking, that 6-month clock is ticking. Then we look at the estate value. If I just put 500,000 in there as an example, again, this is part of the points that I've been talking about, how the court will assess a claim. It needs to know the pot that's available, and that will be specified on the grant as the net estate figure. So we need to know that so that we can be realistic with clients at the earliest stage.
It's probably worth noting here as well, if you pop in the client's details, then obviously, as Eleanor mentioned, we will get that information, and then our triage team would then contact that client within 24 hours to go through the inquiry with them, wouldn't they, before passing it on to the legal team?
So they don't need, you go through this and they don't need to then ring the firm and talk to anybody. If the outcome is that there isn't a claim there, they know straight away, and it's private, it's done and dusted. But if there is a possibility of a claim, they will be contacted by somebody who can help. A specialist will contact them. There is no further obligation on them to sort of pick up the phone and ring round to talk to people. The reason why we ask for ages is, again, looking at the needs and resources of beneficiaries. So it's not to be rude or impersonal to people. It's literally to make sure that we know right from the beginning how, what sort of life expectancy has this person got, and what will they need for their life from the deceased estate. Crucially, we need to know whether you fall into any of the categories. So we've got spouse, civil partner, cohabitee, child or child of the family, and financial dependent. So I'll say cohabitee, and then again, this triggers that point about the 2 years. So what I will say here is that it started on 31st of December 2020, and I will say that yes, still living with Jane at the time of her death. Do you know your value of the inheritance from the intestacy? Yes. Nothing, because we weren't married. And then I'll put in my email address, my mobile number, and I'll say half of the estate, because I was living with her for a long time. We were committed and we were like man and wife. So I will do agree, and submit. So literally a few minutes.
And then basically that pops up a report, which will give the client or yourself the yes, no, or maybe as to the strength of that claim. So it assesses the claim instantly. Obviously, there's a lot of grey areas here, so it potentially could come out as a maybe. There's lots of grey areas that can crop up when it comes to the 75 Act. So if it comes to a maybe, then we will always take the inquiry and ring them and discuss why it's maybe, and whether we can go through with that with that claim or not. Yeah,
and particularly for cohabitees, where it's so evidential and so fact specific. Can I just check that you can see the report that I pulled up? So it literally goes through each legal hurdle. That in itself is helpful, because it's something which the potential claimant, it's not just like a yes, no, or maybe. They can see exactly what a solicitor needs to look at here, and where where there are particular points of note, so situations where 2 years minimum cohabitation period is broken up by periods of separation. So we're telling the person filling in the form exactly what they need to know, and hopefully prepare them for that conversation that they're going to have with the solicitor. But here it says that my claim has failed, but what we want to show with this is the fact that even if this comes through to us and it doesn't quite meet the hurdles, the call is still made, because we know what it's like when you are grieving and when there is masses of information which you know, you aren't yet familiar with, and so providing this to us is simply a route through to allow us to ring you and clarify points. And there may be other avenues that we can explore in terms of claims. It doesn't just mean that that's it, done, but what it does do is manage expectations, and that can be a really important first step for clients.
I think it's worth noting there as well, Eleanor, actually, that we're currently in the process of creating a version 2 of the claim checker. So it won't actually just it'll assess the strength of the claim of the 1975 Act, but we will also be signposting people when it comes to probate disputes, trust disputes, executive disputes, to be able to signpost them and give them a bit more information as to what they can do at those points as well. So we're creating that at the moment. It's going through quite a heavy user experience process, and that will be launched next month. So yeah, but please do have a go with that one.
Yeah, have a play around and see how it might work. But it's there, it's free, it takes a few minutes, and it gives the clients the opportunity to get some issues over to the solicitor in advance of a call. And likewise, you know, we're more than happy to chat anything through informally where any of these sorts of issues come across any of your desks. So just then carrying on and finishing off with more of an overview about the benefits and pitfalls of a claim under the 1975 Act. For spouses, as I said earlier, you can find that spouses are intentionally left out of wills, and likewise that the rules of intestacy just do not work for them. So it means that as a spouse, you're not just bound by what it says in the will. If it's not right, then you are entitled to claim. However, as a potential pitfall, some spouses may look to claim thinking that they will achieve an automatic right to 50% of the estate. However, it isn't that straightforward. The court undertakes the hypothetical divorce assessment, but it will look at the surviving spouse's own resources, of course, and what they have to provide for themselves for the rest of their lives. So if the wealthier spouse is the surviving spouse, and actually the will or rules of intestacy don't provide for them in the way that they expected, then that can mean that any sort of claim, even if they are an eligible claimant, isn't actually going to better their position. For cohabitees, the law does not recognise the relationship. This is the only way to claim for provision if you have not been provided for in a will, and certainly if there is an intestacy. However, as I said, it is evidentially very fact specific. There is a lot of information which needs to be pulled together and provided to the court. It can be difficult, particularly if you're being shut out of a property that you shared. Maybe you don't have access to bank statements because that was always dealt with by the deceased cohabitee, and there can be practical hurdles to overcome in building up your case. For ex-spouses, you know, as I say, it offers a route through resolution of financial matters which have not yet been dealt with. You do need to be divorced. The marriage does need to have been dissolved. And what you can't do as an ex-spouse is, if everything has been done and dusted and the court has made an order relating to the matrimonial finances, if your ex-spouse wins the lottery, you can't then come back and claim on their estate years down the line because you feel like you ought to have been given something out of the pot. If the matrimonial finances are done and sorted, that is it. You can't claim. As a child of the deceased, even if that child was estranged, they can claim. As an adult child, if there was a pattern of financial maintenance there, but yet the relationship perhaps wasn't as strong, then there is still a claim to be pursued. Common pitfall here is if the biological child of the deceased was actually legally adopted by another family, they cannot then claim from their biological parents' estate. The legal adoption trumps that. Somebody that was treated as a child of the family, this is the classic support to people as part of blended families, stepchildren or children that have been taken in by a family. But you have to do a lot more to prove that relationship and the financial maintenance, particularly if there was anybody else supporting that child outside of that family unit. The other thing is we see a lot is that there isn't necessarily a claim for provision so much as it's a claim for a sentimental item or a specific possession of the deceased for sentimental reasons. You can't claim for that. You can only claim for provision from the estate. Anything else, a claim for medals or family photographs, that is something that needs to be agreed with the people dealing with the estate as a specific issue. It isn't something that you bring through bring to the court's attention through this act. Somebody who was financially maintained, we've looked at how this might bring in those people who are left behind by the act, who don't fall into those other sections. So it does extend the reach of the act, but it does still require this financial maintenance to be evidenced. You can't simply say that just because there were sort of periodic or infrequent gifts or support, that is sufficient to demonstrate that you're entitled to something from their estate. The evidential burden is significant here, and it can be very problematic trying to even get these sorts of claims off the ground. So that's it in terms of the benefits and the pitfalls. Appreciate we're just coming up to 1 p.m, so we really have hit the hour, and it was great sort of being able to go through things in as much detail, but I appreciate it's a lot of information. If there are any questions now, I'm more than happy to take them, but recognise that everybody needs to get on with their day. So if there are questions that you want to raise separately, then you can contact either myself or Lindsay, or contact us through the IDRN, and we'll come back to you.
I think there was one question from Rachel in the chat here. So can the claim checker be specifically used for legacy officers, and will I be able to assess the likelihood of a claim? So that's actually really timely and a really good question, Rachel, because I've just answered your query in there, but just for anybody else who's from any charities, any other legacy officers on here today, we've actually just we're in the process of creating a charity legacy version, and it will essentially assess a claim against your charity. So if a beneficiary is trying to make a claim against the legacy, it will assess that claim, the 1975 Act claim, in exactly the same way that we have shown you. We launched the prototype at the ILM last month, and earlier this month, and it went down really well. So we are nearly finished with it, and we'll be launching it towards the end of this month. So please do join the IDRN to keep updated with that and how we're getting on with it, and you'll be able to access it there once it's all launched. So I hope that answers your question. I don't think there's any more in here, Alan. They're just people saying that it would really good piece of CPD. So brilliant.
Yeah, absolutely. Thank you so much, everybody, for sticking with it. And if there are any legacy officers who do want to have any you know, informal chats with us. We are always here to support you. And if you can't find it on the IDRN, if there's a quick question you want to ask, just give me or any of the team a ring, and we're always happy to talk things through from that perspective.
Absolutely. And if any of your colleagues have missed the session today, it'll be uploaded to the IDRN later this afternoon. So please do share away with them. And our next, just to let you know, our next clinic will be in September. We're having August off because everybody's usually holidaying. So we thought we'd hang back till September, and actually bit of a treat for you, because Martin Holsworth is going to come on and take his debut at the Contentious Clinic and provide you with amazing training on LARC versus NUGAS requests, which has been high in people's requests for training on. So yeah, so that's great. If there's anything else from you, Eleanor, or we are happy to wrap up.
Yeah, thanks so much, everybody.